Good evening. This is the February 5th, 2014 meeting of... I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good evening, Mr. Chairman, members of the board.
Good evening.
The Planning Department would like to request that the following items on your agenda, noted with an asterisk, be adjourned this evening, insofar as we have insufficient information for the board to take action this evening. Moving to Part 1, Adjourned Matters, Line 1, Case Number 2011-01, All Season Motor Lodge in Smithtown. Line 2, Case Number 2012-04, Storybrooke Homes in Wisconsin. Line 3, Case Number 2012-02, Carlson Associates in Kings Park. Line 4, Case Number 2009-05, FB4 Realty. Under waiver requests, Line 5, Case Number 773, Scholar Estates in Comac. Line 6, Case Number 1092, Winston Run in Wisconsin. Line 7, Case Number 1139, Jenna Court, Section 2. Under performance bonds extension, under line 8, we have a 280A application for Olivia Estates on Birch Road. We also have on Part 2, 2 closed hearings. Line 9, case number 2010-06, KVC Holdings, MLC Holdings, and DWC Management. And then under line 10, case number 911A, Glen Hill Northern and St. James. Mr. Chairman, these are the matters that the Planning Department requests that the board adjourn this evening.
Is there anybody present who wishes to be heard on any of the matters that were just read, regarding which the Planning Department is recommending an adjournment? Hearing none.
Mr. Chairman, I have a question on two of the items. The fourth item on the agenda, which appears to have been put before this board in 2009. Could you just briefly outline the circumstances of what caused this to languish for 5 years, or to be before the board? I know there's a January 7th letter from council requesting that we put this off till March, but can you just give me a brief history? I'm sure might even predate some other members of the board.
Yes. What basically this is there are 2 zone change applications being sponsored or being held by the same attorney, and he has asked that these be held on the same night, and that's why because they're in the same general vicinity. This is in the Old North Port Road, Town Line Road area. The other application is the Carlson application. FB4 Realty is actually on Bread and Cheese Hollow Road or Town Line Road, and Carlson is located on the Old North Port Road area. Both cases involve town violations that are on the site, and the court is involved in each of these particular decisions. They've been brought before this board, and they held what FB4 first came before the board on its own independently, and immediately requested an adjournment that night, and then came back with the Carlson application, and they've been adjourned several times because Carlson has proposed a new use for his particular property, and we've had several meetings with the town board trying to consider these new uses. It's not a secret, so I'll go through this with the board. I may have mentioned this individually to some members of the board. Carlson is proposing a solid waste processing facility for yard waste. And that's what he's currently doing on his site, which is illegal and not permitted in the town. But the difference is he's proposing to construct an indoor facility. And the processing of this material will be done completely indoors. The advantage of this type of a proposal is that generally the nuisance that you have with the noise, dust, odor is generally contained and it's inside a building, and the odor is maintained within the structure itself. That's the theoretical issue. The implementation issue has a lot of problems with it. So therefore, we are currently trying to figure out how to deal with this. One of the issues, for example, that came up at the last meeting of the town board, and that was 2 weeks ago, some of you may have saw it, was that some of the elements of this particular operation are regulated by DEC. And the town and DEC sometimes do not see eye to eye on the level of regulation that may occur, and big example of that being sand mining. So we are trying right now to figure out what type of regulation we could develop that will ensure that the town can control this particular operation. That's the short version of where we're at right now.
So I gather the application since 2009 has changed or has evolved into...
Yes, they've made a proposal to us, and we are going to consider that. We are going to establish the ground rules on which, or at least the town board is. If they don't proceed on that particular basis, then what's going to happen is the litigation will proceed and the summonses will be prosecuted that are on the properties, both Carlson and F4B.
Okay. All right, thank you.
Okay.
Is there anybody else present who wishes to be heard on any of the matters regarding which the planning department is requesting an adjournment? Hearing none, motion please.
Motion to adjourn items 1 through 10 as read.
Second.
All in favor?
Aye.
Aye.
Opposed? None, all are adjourned.
Mr. Chairman, members of the board, I'd like to move on now to our new hearings this evening. The first case is a request for an extension of conditional final approval. If the board wants, I could bring out the maps, but basically this is the industrial subdivision that was on Southern Boulevard that the board approved. They had to go to the Board of Appeals to obtain some minor variances, and the applicant is requesting an extension of the conditional final approval. We see no problem with it. I'll read the memo into the record. The applicant has requested 2 6-month extensions to retroactively extend the conditional final approval for the above referenced subdivision. The map of Southern Boulevard Industrial Park was granted conditional final approval by the Planning Board on May 1st, 2013. A correction to this approval was subsequently approved by the Planning Board on August 22nd, 2013. The applicant is requesting the extensions because the map was not filed by the January 22nd, 2014 deadline. The applicant has indicated they have not yet received Suffolk County Department of Health Service approval of the map. The Planning Department has no objections to the applicant's request. The Planning Department offers the following resolution for the board's consideration. Be it resolved that the Planning Board hereby grants a retroactive 6-month extension of time to the conditional final approval for the subdivision map known as the map of Southern Boulevard Industrial Park beginning January 22nd, 2014 through June 22nd, 2014.
Okay, is there anybody present on behalf of the applicant?
Good evening, Vincent Pizzulli with the officers of Fort Charlie Curto, the Omni Building, Uniondale, New York. For the record, let me hand up the affidavit of posting.
Sure.
Forgive my attire. The resolution is correct except for one factual statement. This is no need for a retroactive extension. The corrected resolution was adopted on August 22nd. 6 months would be February 22nd or 21st.
I'll stand corrected then.
Okay. And thank you very much.
Okay.
We have a map pending with the health department. That's why we need the additional time.
Okay. Anybody in the audience wish to be heard on this application? Any questions from any members of the board regarding this application? None? Okay. Then in the matter of item number 11 on our calendar tonight, Southern Boulevard Industrial Park number 1151, we need a motion.
Mr. Chairman, I'd like to move that with regard to item number 11, number 1151 Southern Boulevard Industrial Park on the February 5th agenda, that the resolution be adopted as proposed by the board with the modification that the word retroactive be removed.
Second?
Second.
All those in favor?
Aye.
Opposed? None? Motion carries. Resolution is adopted. Thank you.
and
Have a good
evening.
night.
Thank you.
Happy shoveling.
Mr. Chairman, I'd like to move on now to a final subdivision this evening. This is case number 1152, map of Larson Avenue plat in Smithtown. Mr. Chairman, before we begin, this was a matter that we adjourned at a previous meeting because this was in the Halleck Acres area, and we had discussed about the placement of the homes. For your the board's convenience, I put the old maps in, there's 3 of them in front of you so you could see them. And if those are not the maps we're considering this evening, the maps we're considering this evening is attached to your packet, but it does, for illustrative purposes, show you why we changed it. If you look at the homes in that particular area, the homes were set back so far because of the septic systems that we found them to be possibly objectionable to the residents of that particular area. The applicant, along with the Suffolk County Health Department, was amenable to try to resolve this problem, and I'm happy to report that based upon workings with both the applicant and the Suffolk County Department of Health, we did resolve it. And if you take a look at the maps that are attached to your packet, you will note that the house now is located parallel to the homes on both lots, on both streets. They're no longer set back towards the rear yard. This was accomplished in a large part because the Suffolk County Department of Health acquiesced and allowed us to place the septic systems into the rear yard instead of into the front yard. The septic systems on these particular lots are in a very high groundwater area and as such occupy a very large area, and the placements of these septic systems were dictating the design of the subdivisions. So we managed to resolve that particular issue, and planning and the other departments are find the proposal acceptable. With that, Mr. Chairman, I'll read the
This
memo.
is the matter where there's a 2-home subdivision,
Yes.
and there was an issue because the proposed homes on the original map didn't line up with the other houses on each block.
Yes, well, they were actually so far back as to be within the almost the rear yards of the
Right.
neighbors.
All right, so now that's been modified and we have a new proposed map.
Yes,
Okay.
and we think it is an excellent solution to the problem at hand.
Okay,
With that, Mr. Chairman, I'd like to read the memo.
sure.
The applicant is requesting final approval to subdivide a .92 acre parcel into 2 single-family lots. The subject property is comprised from 1 rectangular tax lot that is 400 by 100. The applicant is proposing to subdivide the .92 acre parcel into 2 single-family lots. The property fronts on the street at both ends with 100 feet of road frontage on Larson Avenue and 100 feet of frontage on North Avenue. The proposal is to divide the lot in half and construct 2 homes, one 100 by 2 foot lot facing Larson Avenue and another one facing North Avenue. The site is surrounded by property zoned R10, which is quarter-acre lots. This map was originally scheduled for the December 18, 2013 meeting, but was adjourned because of issues over the location of the homes. This map is a revision of those plans. While the proposal appears to meet all of the lot area requirements for single-family residents, the property contains environmentally sensitive lands, that is, the depth of groundwater of less than 10 feet. In calculating the amount of buildable lot area for a particular lot, all ESL land must be excluded when determining yield. On November 26, 2013, the Board of Zoning Appeals granted a variance to include environmentally sensitive lands into the minimum lot area. The properties will be 100 by 200 foot lots and will not require setback or frontage variances. The elevation ranges from 51 feet to 56 feet above sea level. The depth to groundwater is less than 10 feet, and the property is to be regraded so that the proposed homes are elevated above the natural grade, consistent with the other homes in the area. The site does not contain any wetland, escarpment, or natural surface water features. The property is developed with the 2-story single-family dwelling facing Larson Avenue to be demolished, and the remainder of the property remains partially wooded. The proposal appears to comply with the standards of the Suffolk County Sanitary Code with respect to sewage flow and septic system setbacks for single-family residents. The engineering, highway, and traffic safety departments have no objection. The planning department has inspected the site and has no objection to the subdivision. However, as noted previously, the planning department was initially concerned about the proposed locations of the homes on the property in relation to the setbacks of the adjacent homes. The application was adjourned on December 18, 2013, in order to give the applicant more time to address these concerns with the planning department and other agencies. On January 21, 2014, the applicant submitted revised plans to the planning department showing the proposed homes in line with the front yard setbacks of the existing homes. The applicant indicated that they received permission from the Suffolk County Department of Health Services to locate the sanitary systems in the rear yard, which allowed the homes to be relocated forward. The planning department finds that this layout is consistent with the development pattern of the neighborhood. The revised plans appear to conform to the approved tree preservation and land clearing plan, and modification of this plan will be reviewed by the Department of Environment and Waterways. The engineering department has approved this layout pending the submission of a complete set of erosion control plans. Our recommendation. The following resolution is recommended for the map of Larson Plat from the Department of Environment and Waterways pursuant to the State Environmental Quality Review Act. Be it resolved that the Planning Board of the Town of Smithtown hereby declares itself lead agency on this matter and finds that this matter is subject to the State Environmental Quality Review Act and is classified as an unlisted action pursuant to SEQA. And be it resolved that the Planning Board of the Town of Smithtown does hereby issue a SEQA negative declaration that is a determination of non-significance and environmental impact statement is not necessary in the matter of the application for subdivision approval by Vincent Calvosi for the map of Larson Avenue plat, case number 1153 for the following reasons. A, the proposal does not appear to significantly threaten any unique or highly valuable environmental or cultural resources as identified in or regulated by the Environmental Conservation Law of the State of New York or the Smithtown Town Code. B, the parcel does not appear to suffer from any severe environmental development constraints, that is, no high groundwater, no porous soil properties, and no unmanageable slopes. C, the small size and nature of the proposal mitigates against the significant adverse impact upon the environment. D, the proposal appears to be consistent with the planned use of the parcel and compatible with neighboring land uses. E, the project as proposed in the tree preservation and land clearing plan prepared by Barrett, Bonacci, and Van Weel, licensed land surveyors and dated April 5th, 2013, provides for the retention of a significant amount of existing trees and natural vegetation upon development of the subject parcel. The Planning Department recommends approval and offers the following resolutions for the board's consideration. Be it resolved that the final plat of map of Larson Avenue plat is hereby approved subject to the following conditions. Mr. Chairman, conditions A through M are standard conditions with regard to all subdivisions, with the following specific conditions applied to this map. N, the proposal shall substantially comply with the approved tree preservation land clearing plan prepared by Barrett, Bonacci, and Van Weel, licensed land surveyors, dated April 5th, 2013. Modification of this plan shall be subject to review by the Department of Environment and Waterways. Item O, no further subdivisions shall be permitted. And it be further resolved that the chairman of the planning board is hereby authorized to sign the final plat, thereby approving said plat after the town board has posted a performance bond of satisfactory form and amount. And be it further resolved that the conditional approval of said final plat shall expire 180 days after the date of this resolution and within 90 days after the chairman of the planning board signs the final maps of this plat, unless said plat shall have been duly filed or recorded by the owner in the office of the Suffolk County Clerk. Mr. Chairman, members of the board, that concludes the Planning Department's recommendation.
Is there anybody present on behalf of the applicant?
Good evening, Mr. Chairman. Vincent Calvosa, President of the Calvosa Organization, 19 Millennium Court in Bohemia, New York.
Have you heard the recommendation of the Planning Department and the proposed resolutions that
I
they
have,
as read?
yes.
Are you in agreement with them?
Yes, all of the conditions and the recommendation we're fully supportive of. We're happy that we were able to move the houses forward. Took a little time to do this, and the health department was a big help with Mr. DeRubio's suggestion. Normally, they don't allow the septic systems to be placed in the rear yard of new homes these days. So when Walter Hilbert at the health department heard Mr. DeRubio's concern, he said to keep within the nature and character of the neighborhood, he was willing to allow us to put the septic systems in the rear yard, so that was a big help. And that was a concern of ours, and we're certainly pleased that we're able to move the houses forward also.
So you want us to approve the resolutions as they were read and as the map is currently modified?
Yes, that would be the request, that you approve the planning department's recommendation, yes.
Okay. Is there anybody in the audience who wishes to be heard on this application? No. Okay. Any questions from any members of the board?
Frank, I have a question. It's just the print on the attachment to tonight's agenda is so small. In comparison to the old, the house fronting on North Avenue was going to have a 98-foot front yard, if I'm not mistaken, and it's been moved forward closer to north?
If I may, I have a larger map that may be helpful.
Yeah, I just wanted to see what the front and rear yards will be under the new design. The print is so small.
You can give it to them.
This is just both of
Got
them
it.
combined together,
Got it. Okay,
40
40 here and 128,
and then 40 on this side.
and this is 120.
Here's the front lines of the houses.
Got it.
So here's this
Okay.
neighbor, and here's this neighbor here, so they're in line.
Yep.
And here's this neighbor.
Understood. It was just so hard to read on
And they
this.
were further back. You can see
Understood.
where they were before. Here's the house, and there's the house there. So it was like in the rear yard.
Understood.
And the same thing, this was in the rear yard of this property.
Yep,
So
all right.
see that?
I see it from here.
Yeah.
Mr. D'Amato, just to let you know, there's no variance requested by the applicant on any portion. The only variance that was necessary was the building on environmentally sensitive lands, which was granted by the Board of Appeals. The setbacks and all the side yards and rear yards meet all the zoning codes of the town. Okay?
Understood. Thank you
Correct.
both.
Thank you.
Any other questions from any other members of the board? All right, hearing none. As to item number 12 on tonight's agenda, map of Larson Avenue plat number 1153. We need a motion for the secret negative.
In the matter of map of Larson Avenue plat, number 1153, motion to approve the secret negative declaration in accordance with the recommendation of the Planning Department.
Second.
All those in favor?
Aye.
Aye.
Opposed? None. The motion carries. The resolution is adopted. Now we will need a motion regarding the approval of the map.
In the matter of the final plat of map of Larson Avenue plat, number 1153, I move that we adopt the resolution as read in accordance with the recommendation of the Planning Department.
Second.
All those in favor?
Aye.
Aye.
Opposed? None. Resolution carries. Motion is adopted.
Mr. Chairman, we need the matter of the performance bond. I'd just like the applicant, did you receive the draft copy?
I did, yes.
Okay, that's fine with you? Okay.
Fine.
Okay, Mr. Chairman, I'd like to ask the board to consider the following performance bond resolution with regard to this particular matter. Be it resolved that the chairman of the planning board be authorized to sign the performance bond estimate for the map of Larson Avenue plat, number 1153, in the amount of $18,435, and establishing an inspection fee of $1,475 and a cash deposit of $1,000. Therefore, the amount of the performance bond to be posted with the town shall be $17,435.
Okay. Any comments, sir, on that portion of
No,
the...
no comment. I've read it and I agree.
Okay, thank you very much. Any questions from any members of the board? None? Okay, as to the performance bond estimate, then we need a motion, please.
In the matter of the performance bond estimate for the map of Larson Avenue plat, number 1153, I move that we adopt the resolution as read in accordance with the recommendation of the Planning Department.
Second.
All those in favor?
Aye.
Aye.
Opposed? None? The motion is adopted. The motion carries. The resolution is adopted.
Thank you, Mr. Chairman, members of the board.
Thank
Mr.
you.
DeRubius, thank you.
Mr. Chairman, that concludes the matters for this evening.
Okay. Before we adjourn, I believe we were notified that we are going to move the February 19th meeting to February 26th.
Yes.
All right, everybody okay with that? All right, so with that, we would need a motion to adjourn.
Motion to adjourn.
Second.
All in favor?
Aye.
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 Opposed, none? We are adjourned.